Hello everyone, and welcome to this presentation on the regulatory traps waiting for AI in security. I'm Pauline Norstrom. So today I'm going to be introducing myself, going to give you a synopsis of what I'm going to be covering, and then walk through a number of points which will be takeaways from this presentation. So understanding AI impact and risk, questions to ask AI system providers, takeaways from the EU AI Act, and also an overview of the UK AI and biometrics regulation and some further pointers towards guidance you can go and have a look at. So first and foremost, a little bit about myself. So I'm the founder and CEO of Anekanta Consulting and Anekanta AI. These are both international AI research and innovation brands with a high-risk AI focus. We've just joined with Face Comply, which is a partnership on facial recognition risk. Also, we have just been featured on the UK government's CDEI website, the AI Assurance Portfolio, with our AI Risk Intelligence System. I am actually personally an AI advisor to several organisations, the BSIA, the IOD, and a company, Archangel Imaging. I'm a former chair of the BSIA and now an elected honorary member. And I've just picked up the chair role for the Biometrics and AI Special Interest Group. I've been in security for over 20 years, and that's technology applied cross-sector and mostly in video analytics and later AI and digital technology. I'm a UK and international statutory board director and a fellow of the IOD, and I work with a number of international ethical AI guidance and standards bodies. So what I'm going to cover today is to explain the range of impacts and risks associated with AI used in security. There are a number of regulations emerging around the world which will affect AI and security. I'm going to touch on the effect of the EU AI Act, which will be enacted early next year, and the effect that will have on biometric-based AI systems, and also look at some insights into the current government white paper, that's the UK government, for AI regulation, and its juxtaposition with Europe and the roadmap for AI and biometric regulation in the UK. So our first topic is getting to grips with an understanding of AI impact and risk. So to assess AI impact and risk, it's really important that the definition of AI is understood. Now, there's no current global definition for AI, but that will change. And that's been posing a little bit of a problem. I think the EU AI Act will be the first to actually define it in law. Now, why this has been a problem and is a problem is that if AI is not consistently defined, the evaluation can be subjective and the impact and risk implications unmeasurable. And if you can't measure something, you can't manage something. So we're waiting for this new definition to be released in law, which will be very helpful to clarify a few things. But first and foremost, it's really important to appreciate that AI is not just generative AI. It's obviously in the news on a regular basis. It's not just ChatGPT, Bard and Llama and so on. The traditional AI systems may contain different AI techniques to achieve their objectives. And those techniques may include deep learning, neural networks, used for object detection. One of the AIs at the heart of facial recognition software, machine learning techniques are used for data analysis, for identifying trends and making recommendations and so on. So it's not just Gen AI, and the traditional systems mustn't be forgotten because they're the ones that are implemented in industrial applications. So back to the definition. So if that is consistent and it's applied to AI systems in development and in use, it's possible then to assess the impact and risk. What we found is that AI technologies used in security are not always obvious. But what we find is that there are common libraries and algorithms which are classified as AI models and techniques, which can be found at the heart of many security AI systems. So I mentioned the EU AI Act and a definition in law. Now, this will be the first time we'll see this, which is really great. And also that the leadership of the OECD has been followed by its member nations, in that the definition is starting to appear in guidelines and AI strategies. So the EU AI Act definition, which we think will be the first law to embody this definition, is derived from the OECD. And fundamentally, it's described as a machine-based system that's designed to operate with varying levels of autonomy, that can, for explicit or implicit objectives, generate outputs such as predictions, recommendations, or decisions that influence the physical or virtual environments. Now, the words are highlighted that you may recognise as being features of the AIs you're using, and in particular the outputs, so the decisions, and what can be influenced. Well, in security, it could be to advise, it could be to actually activate some other hardware, or to help decisions to be made about a given situation. And without the definition being embodied in law, there is another area that you can look to, actually, to adopt a consistent approach to the definition, and that's a new global standard which is called long definition ISO IEC 228989. And this is artificial intelligence concepts and terminology. It's great news that this document is issued free of charge. So you can go and download that from BSI, AI Standards Hub in the UK. And the reason for that is to help to embed standard terms and definitions. And the definition, no surprise, it's aligned with the EU AI Act as well. It's slightly abridged, but it is explained, so it basically holds the same meaning. And that's an engineered system that generates outputs such as content, forecast, recommendations, or decisions for a given set of human-defined objectives. And the standard does go on to say that there are techniques behind this. There might be a model that reasons on data or on knowledge. There's a process. Tasks can be undertaken, and the system can operate with varying levels of automation. So this is starting to sound familiar, and as you hear this definition more frequently, it's easier to apply it to the AI systems that you're using. So we talked about AI impact and risk as this topic, but how do you actually go about identifying impact? It is quite difficult when there are no laws, and the definition has also been inconsistent, but there are ways, and unfortunately some of those ways are to see what harms have been caused. Not something we would recommend, but without any kind of governance, there can be no emergency stop button. AI might be getting out of hand, and they may be doing that for some time. And this can result in real human cost and impact. So harms to people might be privacy, might be something else. And ultimately, this could cause reputational damage. And we use HAL as a good example quite frequently, in that HAL, if you're not familiar, is from quite an old movie called 2001 Space Odyssey. And HAL controlled a spaceship, and it was an AI based computer, and it decided to do away with the crew because they were getting in the way of the mission. And that's one of the doomsday scenarios that's been put forward for generative AI, because HAL is kind of an early form of that. And the idea has been around for a long time. So how do we actually go about identifying it and also mitigating? So first and foremost, what is impact? Now, I mentioned privacy. Generally, it means harms which may be caused by using the AI system. In Europe, that refers to the interference with the fundamental rights, health and safety of individuals, and is rooted in the European Charter. In business, it generally means impact on stakeholders, which may affect the financial performance of a company. And stakeholders, generally shareholders, are at the top of the list. And employees customers, the whole supply chain, and the public may be affected. And in GDPR, we look at the law that has a definition in here. It's essentially impact on privacy and fundamental rights. But impact at the moment may be treated differently by the developer organisation than the end user organisation. And this is where the standards and the new regulation and the proposed regulation, they seek to introduce some consistency about the way impact is actually considered and addressed. And in security, we have a number of AIs at play, and they are combined. They can be standalone. Multiple techniques are in use, and generally to provide better situational information to determine threats. Often multiple data sources are being analysed. Multiple AI techniques and APIs are in use, which bring data in from other systems. And when you start combining data sources together, this of course raises a number of concerns about privacy, in that those data sources may not have been intended to be used in the way that they end up, and that opens up a whole debate about anonymisation and pseudonymization, which is taking a little bit of data away to obscure the full data set. But if you bring those together and you do use an AI like generative AI, it could work it all out for you, and there could be all sorts of inferences generated from these data sets. So you need to be aware that there could be effects that you weren't anticipating, and these are the impacts that the AI system causes. But overall in this industry, the AIs are used to draw the human's attention to unusual activities, which is generally to protect people from harm, but we don't want the AI to cause the harm as well. So there are some new questions to ask. Certainly when you bring data sources together, you need to be looking at whether that's a change of use of the data. And I do talk about this quite frequently, actually, in terms of security data sitting within its own definitions in GDPR. There is an exemption of a kind which enables the use of much more data, shall we say, than otherwise would be allowed if it is in the public interest and for security purposes. But if you change that use, you're going to sit within the full GDPR scope, and that could affect sort of impact on equality, bias, explainability. There could be fines here, there could be damage to reputation. There could be an employment tribunal dispute as a result if you don't consider that change of use very carefully and consult and inform employees, for example, if they're being subjected to an AI that was for security and maybe the company is now wanting to use it for employee monitoring. So there are certain areas that need to be looked at. Now, I've added a slide in here for deep fakes. Now, this presentation isn't about deep fakes, but I have to mention it because it is one of the side effects of some very good technology that is being used to create synthetic data sets, which can actually improve the quality of facial recognition software by creating the right balance of demographics in the training data. But that software can also create false images. So I think it's actually only a matter of time before somebody's convicted on the basis of fake evidence, which has been generated through a deep fake, or someone may not be convicted for that reason. And it's something the industry needs to be aware of. How do you stop this? Well, you have incredibly robust physical and cyber security measures and control access to the systems to ensure that there can't be any injection of data to that system, and that the evidence trail starts really at inception when you first gather the data. Otherwise, what happens, digital evidence is ingested into the criminal justice system at the point at which the police take that evidence, and it doesn't necessarily consider the trail of activity, should we say, on that digital data prior to that being ingested. So it's a wake-up call. I'll keep mentioning it because I think it's only a matter of time there'll be a wrong wrongful conviction, and that it could call a lot of cases into question. So everything changes with AI and AI systems in terms of how you procure these systems, how you manage them, and take care of impact and risk. And one area which is an important consideration is looking at the questions that you need to ask a system provider. So that, excuse me, the provider could be a developer. A developer isn't necessarily an individual, it's a development company placing AI on the market. It could be a provider, someone that is using a library and embodying that in, or an algorithm embodying that in their own implementation. It's important that you know what to ask them. And the reason why I'm stating this now is that these are questions that you will need to ask under the EU AI Act. And if you're based in the UK and wondering why is that important, I will explain that, because it is quite wide-reaching in terms of covering AI decisions that are used in Europe, regardless of whether the system actually is hosted in Europe. So what do we need to be asking the system providers? So what are the intended use cases? Not all system providers explain this. They will need to do that under the EU AI Act. How is the AI system trained and tested for bias? Well, if you are a systems integrator, you will need to be able to answer the questions of your user in this regard. If any issues come up, if someone is consistently locked out of a AI-driven access control system, it might be because the demographic isn't dealt with very effectively, or for other reasons. So you need to be asking that question. Are they using common libraries? If so, what are they? And where did they come from? Where did the data come from? You need to get this into your language and be aware that these are important questions that lead to understanding a lot about the quality, and not just the quality, but makes the system comparable with other systems. You might ask what certifications they've achieved. There aren't many at this stage, other than National Physical Laboratory and also NIST undertake a number of tests on facial recognition software. You might ask, do they have an AI risk management system? Again, that's an important factor of the EU AI Act. Do they have an AI management system? Now, there's a new AI management system coming to market, which is called ISO IEC 42001, which the language attached to the standard is starting to consider it as the global standard for AI management. And it's a quality management system that can be used standalone instead of ISO 9001 or alongside it. And it's for the provider, for the developer and the user. And it's a great way of actually walking through in a structured way every aspect of definition, impact and risk, and how to manage those risks. You may want to ask what ethical principles for responsible AI have they implemented. These principles are starting to become embedded in a number of standards, also the UK government regulation white paper, the EU AI Act. And if they have implemented them, then it gives you the ability to ask further questions, such as questions around transparency and explainability. How does it work? How does it make decisions? That's if there's a dispute about how a decision might be made. Are they working towards EU AI Act compliance? Very important at this stage, especially for biometrics-based AIs. The Act will come into force early next year, and for the very high risk and prohibited AIs, providers have just 12 months to prove that they're compliant with the law. So there's a bit to do. Also, have they defined the risk category? If they do that, then the whole value chain that follows has a better chance of assessing impact and risk. So this is just a sample, but certainly those conversations need to be a bit more detailed in terms of asking the right questions. I mentioned Clearview AI, which is quite a well-known case study now, and I'll mention it in the context of lessons that they learnt as a result of scraping social media sites for images of people. They took a long time for the regulators to figure out what to do about this, and the system prevailed for some time before they received some fines and guidance from the regulators. That's the important part. So they don't do it again. And some of the lessons learned do relate to some of these questions, such as where did they get the data from? And should they have it? And should they use it in this way? These are really, really key questions, and they're in the list prior to this slide. And if this had been asked maybe a little bit more in the early stages, then they may not have got into this situation. But how they've addressed this, they've listened to the regulators, and now they vet the customer. But this is bringing in the entire value chain. So it's not just a provider makes a product and their limit sits at the edge of their products. They are having to take great care about who actually uses the product, and that it is in hands of trained and authorised users. And they're effectively using it in more ethical ways to find people, and Ukraine is a very good example. So moving on to the EU AI Act. Now, this is a very, very big and complex piece of legislation. In its current form, it's probably around 500, 600 pages, which is quite a lot to digest. And I wouldn't recommend that anybody goes and reads the compromise text or the amendments. The final act will emerge very soon. It's going through a process in Europe currently called the trilogues, which you may have heard that expression. And it's a process of negotiation between the member states and the Commission and Council to determine which of the amendments stay in or not. One of those amendments is a complete prohibition of facial recognition software in a live setting in public places. So for security, there are some concerns about that prohibition, because there's plenty of evidence to support the case for using it in terms of counter-terror, but also finding missing persons. So there is a campaign from the industry to attempt to influence that decision. So in the meantime, I thought it would be helpful to explain a case study, which I have talked about before, but I'll use it in a different context here. It's not so much a doomsday scenario, but I think a really good example of how learnings from harms have then been used to underpin the law. And this is the Dutch government problem, whereby they procured an AI that automated racial profiling. And it did that by picking up on mistakes on forms for child welfare claims, and established a link between dual nationals and mistakes, and assumed fraud in pretty much every case, which was wrong. And it prevailed for 5 years before it was actually discovered and addressed. But there were so many lessons learned from this: lack of governance, no explainability. Those who were using the system couldn't challenge it. So when they had complaints, they just had to say that's what the system says. The department was apparently incentivized to use the system because it's a very, very expensive system to procure. So they needed to generate fines. And the underlying structures in that system were found to be biased. So they just made a big bias machine, which really harmed a lot of people. And the Commission really wanted to avoid any repetition of this in the future. As a result of this issue, the Dutch government resigned to acknowledge the gravity of the situation. But the remedies were actually foundational to the EU AI Act in that biometrics and biometric profiling and categorisation have been further defined, shall we say, way beyond GDPR. So I won't go through every detail of the EU AI Act, really just what you need to know if you're using, developing or providing security AIs into Europe. The prohibited AIs are those that categorise on the basis of biometric data in certain contexts, such as government, social access to social benefits, also in employment and the workplace. And live facial recognition is currently on the list of prohibited items if used in publicly accessible places, which includes those managed by private organisations. Can be used in private settings. And then high risk, fundamentally, I would say that's a very large proportion of biometrics-based AI systems sit in this category. And then the limited risk, which is the yellow, requires transparency. And that might be fairly generic object detection AI, which is detecting people in images, but not gathering any other data. Now, it may look onerous, and there are a number of requirements that go along, and these are CE marking for facial recognition, software conformity assessments, registration of the software with the authorities, transparency requirements, but fundamentally the implementation of AI management systems, risk management, and various processes to manage any changes in the software as it's in operation. And this brings the user and the provider much closer together in terms of collaboration. And that's a good thing, because the feedback is accelerated as a result of that improved connection that is embodied in law. And I mentioned biometrics and new definitions or clearer definitions. Biometric data is defined in GDPR, and that is remaining in the Act. And I won't read it out there. You can read that at your leisure. But the new pieces which have come in are the biometrics-based data and the emotion biometrics. So data that's generated as a result of a human interaction with something, which might be a keystroke on a keyboard. So if you're monitoring the use of equipment, and that includes how people use it, that's a biometric-based piece of data. Emotion biometrics, there are some biometrics which are banned altogether. Those which assess emotional state in a workplace setting and law enforcement. And there's a reason for this. It's considered that behavioural analysis, so emotion biometrics, people's reactions could be different depending on the culture, on them as individuals, whether they suppress emotions, whether some cultures are more overt than others. And it's considered too difficult and too risky to actually allow this to occur in certain settings, especially in the workplace. Biometric processing is further defined. So we will have heard about identification, that's live facial recognition, for example. Verification to confirm it's a person. That has been downgraded in terms of risk to sit really in the GDPR requirements, but also with transparency under the Act. Categorisation, that arose as a result of the Dutch government issue. That's been defined, profiling and inference from other data. And this is where combining data sources together can be risky if you can infer certain biometrics. So there are lots of traps in here, and this is a taster. It's just the surface of what you need to be looking at. And what's important to take away from this is that dependent on the use case, so the context of the use, the different risk categories apply. And I think the best example here is facial recognition. Live is banned, verification isn't, and it actually sits in quite a low risk, limited risk category. So looking at some of the new risks for security systems, I mentioned why the EU AI Act is important to UK-based providers or anyone outside the UK, in fact, because AI decisions used in Europe apply to cloud-based systems hosted outside the EU. So a decision used in Europe doesn't matter where that system resides. That whole system will be subject to the Act. There's a new directive called the AI Liability Directive, which may allow a presumption that the AI caused harm if the developer or user does not comply with the Act. Is a presumption of causation. And what that means is that the chain of causation is traced through the value chain. right back to the non-compliant component, you could assume. Developers are actually accountable for the consequences of the misuse of their AI systems. And that is a really big point to take away from this, because commercial terms, which generally ring-fence liability and deny consequential liability as a result of the use of a system which may be outside the control of the developer, those contracts may not be robust anymore. And in law, they may still be liable. So there are a few contract points to look at. And developers must define their use cases and provide the user with information which explains how the system could be used safely. And the user must report an AI system to the developer and to the authorities. That's if the AI system causes harm in accordance with the instructions. So there's some new things in there that weren't there before. Typically, the industry develops, sells its products, and the integrator and user deal with the consequences, and the developer is outside that loop. This new law brings the developer into the loop. So looking at UK AI and biometrics regulation. So the key points in here are covered. There is a white paper which has been produced by the UK government. And the key area to look at is that the white paper is based on a number of principles which are founded in the OECD, which is great. OECD principles have been used in the EU AI Act and also across standards and so on. And fundamentally, they cover these areas: and safety and security and robustness, transparency, explainability, fairness, accountability and governance, contestability and redress. I won't go through all the wording on the slide, but fundamentally this allows those questions to be asked of the AI developer in terms of, do they have the systems in place? Have they designed the system in a way that allows it to be explained? Is it biased? Is there a accountability and governance in place? And is a harmed party able to contest it and seek redress for those harms? So really good solid principles, which we hope will go on a statutory footing. The moment they're non-statutory, which means they're not embodied in the law. The regulators for each sector will take these on and then decide how they are going to implement. And we hope that happens quite quickly. So on to AI-based biometrics. The biometric regulation in the UK sits between regulators currently, and that can be a little bit confusing. We hope this will settle, and we do find that most biometrics products in security are now AI-based, in fact. And how this was regulated before, well, the Biometrics and Surveillance Camera Commissioner
is or soon not to be a non-regulatory oversight of public systems.
And that will be absorbed into the new Data Protection and Digital Information Bill. And it was the Protection of Freedoms Act that required for there to be a Biometrics and Surveillance Camera Commissioner. And what went along with that was a code of practice, which had to be implemented by public and also public-private partnerships. That will disappear. And it looks like police use will be regulated by the Investigatory Powers Commissioner. Private use, we're not sure. AI regulation, perhaps. But we do see that a vacuum has been created. But we're hopeful it will be addressed. And this leads us to really recommend that voluntary good practice and standards are absolutely crucial at this time. So I was involved in the development of the BSIA's guide to the ethical and legal use of facial recognition software. It leads on the OECD principles to ensure human agency oversight, robustness, accountability, diversity, and so on. And refers heavily to GDPR, in fact, and the ICO's framework and guidance. And on the right, the diagram is walking through the process of assessing whether it's really necessary to use the technology. And further on from the guide, over the last 12 months, the group in the BSI committee, and I do sit on that committee as well, it's chaired by the BSIA, have developed a new standard called BS 9347, which we hope will go to market towards the end of this year. And it is an actual code of practice now, which will be embodied as standard for the ethical use and deployment in video surveillance systems. And it considers the entire value chain, and it encourages the use of the trustworthy principles right the way through the standard. So each one of those stakeholders, so the developer, systems integrator, the end user, each have a set of guidance notes that they can follow that enable them, if they follow them, to actually embody these principles of trustworthiness right the way through, from their purchasing decisions to their system design into the actual use of that system. We're very excited for that standard to come to market, so look out for that. So that concludes, and in summary, you should have taken away an understanding of AI impact and risk, the questions that you need to ask the AI system providers, what the EU AI Act impacts in terms of AI system decisions, and also a brief overview of the UK AI and biometrics regulation. And if you'd like to seek further guidance on any of these points, there is a national AI strategy. There is an AI standards hub, which the UK government urged a number of organisations to get together and produce, BSI, National Physical Laboratory and so on. And that is an absolutely fantastic resource. You can go in and see what's happening with all the AI standards. OECD, GPAI, which is the Global Partnership for AI, ICO, BSIA, BSI, EU AI Act and the EU AI Liability Directive. So that concludes from me. I hope you enjoyed the presentation. Thank you very much for listening, and I'm happy to receive any questions through Security Buyer. Thank you very much.
Well, thank you, Pauline, for joining us for another session at Security Buyer Live. It's always great to catch up with you, and your insight is always invaluable. And thank you for taking the time as well to join us for this Q&A. So you mentioned briefly about the new regulations that are primarily directed towards biometrics. Do you think that this will impact the progression of biometrics? Is it still an emerging technology in the wider context of security?
I don't think it will impact the progression. I think what it will do will enable developers to really differentiate themselves and show a mark of quality through compliance with the Act. And although the Act initially sounds onerous, actually, there are new systems and processes that need to be in place. And monitoring systems that gather market feedback are always helpful to developers. So it will, if anything, help them to develop better products, but certainly it should help them to, let's say, differentiate, so they can actually show that they are responsible. And in fact, for some of the biometrics that are prohibited, there are other ways of using them, and we're not totally certain they will be prohibited, in fact. But for the other uses, it's a matter of learning the rules. And then once those have been embodied, there's some training to do within the organisations. Then there's a really nice system that is very clear and really sets out the guidelines to the extent that everyone that engages with this should be able to explain what their AIs are doing, what the biometrics are doing. And that, if anything, will increase adoption because it reduces concerns about trust and what the AIs are doing and how they're being managed.
That's definitely a good positive outlook, considering when there's change, when the industry's faced with change, there can be a lot of negativity there.
Of course.
So it's really good to see that. And also, given the constant changes in AI and its capabilities, do you think the manufacturers and businesses are prepared for these changes?
I think they, if I were to say they don't know what's going to hit them, that's based on our research. Generally, some companies are really ahead on this and they're already preparing, and well done to them. Some kind of responses we get, so what's the EU AI Act? Which one? And that suggests it hasn't quite made an impact on them in that they consider that they need to look at it. And if you think that developers, manufacturers didn't need to consider the use of their products historically. This is a new concept for them, that a user might actually get them into trouble, and they'll be in trouble if they don't define what the AI is doing. So I don't think manufacturers are ready at all. Some users are looking at it, and I would urge those watching this, this session, to really take action quickly, because those high-risk AIs will attract fines much faster than the otherwise sort of general sort of grace period for the introduction of the Act.
And the definition from the OECD that you showed in your presentation presents AI as having to have autonomy by definition. So do you think the rules of autonomy and human intervention will change given some of the risks that are posed by AI?
I think it will certainly attract a better definition in terms of what human oversight actually means. Now, we've gone into this in some detail in the standard for facial recognition ethical use in terms of when human oversight should be in place and what that should comprise. But in terms of defining this, there's a whole range of analyses that you could apply to this problem, including whether human oversight is actually meaningful or not. And this is where explainability is very important, in that, and training, in fact, so that the operator of that system, who might be a frontline worker, is actually aware of what it is they're agreeing to, because we do know there is a human effect, which is follow the software, do what the software says. So we need to train people to challenge the software and interpret its results, but importantly, understand it, so that if something, so the default position of confusion isn't agree with the software. The default position of confusion is human makes a decision, and this is something that the industry is grappling with already, and there will be further definition. But the human oversight issue will be standardised. It's in the standards groups. It's being debated. So I think it will become easier. But what we may see is a need for license. I'm a great supporter of licensing, and I do believe facial recognition software usage could be licensed, and there could be levels and layers of training that could go in there, which would help to professionalise the use of the product as well. So I'd look at things from a positive outlook, because we're in control here. We're the humans. We operate this in the way we want it to be operated. But if there are no guardrails as I describe them, then this is where you run into difficulties. So it's definitely going to be debated a lot. You know, what's the latest debate is what's a human? So we're going to have to define that. As opposed to a robot, you know, humanoid robot, apparently sentient robot. So lots to debate.
It's definitely an interesting road ahead. And I think you're right. I think it's the education and training aspect to, if people are aware what the AI is that they're using their product, how the algorithms change, where the data has come from, and how to present that with transparency to the user. I think given that education, we should see a positive future, hopefully.
Yes.
You also briefly mentioned pseudonymization, which is a section of AI that is in particular in surveillance, quite interesting as of late, and particularly, for example, in the healthcare space when it comes to patient privacy and confidentiality. Do you think that this will play a big role in the future of AI ethics in a wider context, in more of the public domain?
Definitely. So pseudonymization is a very difficult thing to do with images which contain rich data. So you may block out the person, but you've still got the context. So you can never really properly pseudonymize video images because the contextual element comes along with it. And it's quite easy to work out. There's only one individual going into one place. That happens at certain times of the day. You're going to be able to identify them, which would be a problem. The concern that we have is where you have a pseudonymized data set, you may be able to infer if you analyze the rest of the data. But if you then start putting data sets together, and this is what AI is really good at in terms of analysing across sources. You could defeat pseudonymisation altogether very, very quickly. And there are measures and standards that are in place and are being developed to address these issues. But you can't get away from good human governance of these systems, and not to defer to the system, but actually to have a good, solid human process in there, which goes right the way up to the board, and what the board considers to be its responsibility and accountability for the use of the data, and then the further ongoing processing that might infer all sorts of things. It's really quite a concern, but these matters are being discussed and they will be addressed.
And lastly, is there anything else that you wanted to mention or advise before we part?
Really to urge the industry to really look at the UK regulation. It's not statutory yet, but there are many aspects of it which are moving towards a good alignment with other approaches. The EU AI Act will become law early next year, and it's quite a lot for an organisation to take on board in putting a management system in place. If anyone's implemented 9001, it's not trivial. And with a new system, I would suggest that they start looking at it now and not delay.
I suppose be prepared and be prepared, and don't be scared to ask for help.
Absolutely.
Thank you, Pauline. Your insight's always really engaging and insightful.
You're welcome.
And invaluable to our conference, so thank you. If anybody has any further questions, please don't hesitate to reach out to Pauline on the platform and you can find out more. Thank you.
Thank you, it's been a pleasure.